Hey, so today we're studying Washington Brokerage Management. We're getting ready for the Washington State Managing Brokers exam. It's more advanced than just the basic broker exam. Managing broker means you can have your own company. There's three portions to it, and one of those is Washington Brokerage Management. I'm going to kind of go over the basics of that today. There's a number of sections. There's broker relationships, broker supervision and liabilities, trust account, record keeping and fraud, recruiting and selecting, training, productivity, leadership, and then a final exam. So in brokerage relationships, I'm going to open this up and kind of read through it for you a little bit. The objectives are, upon completion of this section, you should be able to accomplish the following. Describe a specific firm, designated broker, managing broker, and broker licensee duties under each of the following categories: seller agency, buyer agency, dual agency, and non-agency. So for the first part, we're going to go over, there's 14 slides in this. And in broker relationships, brokerages and their affiliated licensees, brokers, enter into agency relationships all the time. It's essentially the basis of the brokerage business. There are multiple types of agencies that the brokerage will engage in depending on whom it represents in a transaction. It's interesting to note that the relationships formed under agency law are transaction based. This means in most cases, a broker will enter into an agency agreement with a principal for a particular transaction, but there's nothing precluding the principal from beginning another agency relationship with another broker or brokerage firm for a separate transaction. As a real estate broker, you work on behalf of others. The laws regarding a broker's duties to their client are of critical importance and are known as agency law. Agency describes the relationship between a principal and an agent. Agency law governs this relationship and the requirements of the agent. That is a mouthful. So first, let's define what an agent is. When a person acts on behalf of another, that person is known as an agent. The agent in our case is a real estate broker, is acting on behalf of the other party in the relationship, the client. The client can also be referred to as a principal, which means there's an agency relationship. On the other hand, the term customer refers to a relationship where one person is assisting another, which is usually not an agency relationship. Agency does not just apply to clients and brokerages. It also exists between the broker and their firm. The agency relationship between the broker and the affiliated licensees carries responsibilities for both the designated broker and the licensee. Let me read that paragraph again because the terminology on this is important. Agency does not just apply to clients and brokers. So it's not just me and my buyer. It also exists between the broker and the firm. It's me and my managing broker. The agency relationship between the firm and the affiliated licensee, that's me, carries responsibilities for both the designated broker and the licensee. An affiliated licensee is another term for a broker or managing broker working with a brokerage firm. Licensees are considered sub-agents of their designated broker. I'm a sub-agent of my designated brokerage. A sub-agent is an agent of another agent. So I work for my boss, basically. Such as a real estate broker who is a sub-agent of the real estate firm who is the agent of the client. So in the house that I did an inspection for this morning, my brokerage actually works for my buyer, even though I'm the sub-agent that the buyer is working for. The licensee is referred to as having a sub-agency relationship with the brokerage firm and is considered to be a general agent. So apparently, I'm a general agent. Good to know. So I'm a general agent and I'm a sub-agent of the brokerage firm. And my brokerage firm works for my client. They are the one that actually has the contract with my client. Prior to 1996, in Washington state, real estate brokers were bound by a fiduciary relationship when acting as agents on behalf of a principal. A fiduciary relationship is when the principal places trust and confidence in the agent and grants broad responsibilities to that agent. In 1996, Washington state passed a law outlining agency relationships and their limitation in real estate. Because it is a written law, the responsibilities are known as statutory responsibilities. So there's statutory responsibilities that I have to my client because it's a written law. The change was designed to be more specific to real estate brokerages. The change is written in RCW 18.86.110. I would take the time to read that because many times over the years, it has come into play what I can and cannot say about my client, be it a buyer or a seller, when somebody asks me a question. And if I misspeak and violate my confidentiality, or on the flip, underperform and don't say what needs to be said, I'm not representing my client to the best of my ability. The duties under this chapter are statutory duties and not fiduciary duties. Statutory, remember that they said that that was written. This chapter supersedes the fiduciary duties of an agent to a principal under the common law. The common law continues to apply to the parties in all other respects. This chapter does not affect the duties of a broker while engaging in the authorized or unauthorized practice of law as determined by the courts of the state. I am not a lawyer. I'm not practicing law. I need to say that to everybody I work with. I don't write real estate contracts. I fill them in. I am not a lawyer. I'm assisting you in a transaction. Duties of a broker to all parties. In Washington state, regardless of whether a broker is an agent, the broker owes the following duties to all parties for whom they provide real estate brokerage services. 1, exercise reasonable skill and care. Do your job. 2, deal honestly and in good faith. Yeah, that's a basic, and sometimes that gets a little sketchy. If you're not sure where that falls, talk to your broker. Like I said, I've had people ask me questions about a seller. Maybe I have a seller that has a substance abuse problem, and it takes me days to get something signed because I have to track them down. It is my job not to relay that to the other parties because that's not their business and it's not my business. The only thing I can say is I'm attempting to get these signatures from my client. I will facilitate this to the best of my ability, and please be patient. Present all written communication to and from either party. Disclose all existing material facts. Did someone get killed in my listing? I've been in that situation. Is it my job to relay that situation or that information? A broker question. I need to go to my broker and say, do I need to disclose this? Should I disclose this? If someone asks me a direct question, a lot of times I've paused over the years and tried to come up with an answer and had to say, hey, let me get back to you. And then I've gone to my broker because I have to make sure I'm being honest, but I'm also representing my party to the best of my ability. And as far as all written communication, even if I already have an offer on a property, if I get another offer that comes in during the pending timeframe, I need to give that to my client. And as an agent that's represented a lot of investors over the years, a lot of times people have said, we don't care if there's already an offer. send my offer across so that they have it in case something happens with that other offer. And many, many times we have ended up being the buyer that buys the property. So that's just something to know as far as how this works. Account in a timely manner for all money and property. When I get your earnest money, I'm taking it straight to escrow. I'm not holding it over the weekend. I'm not putting the check in 17 different coat pockets. Not to say I haven't done that in the beginning and learned valuable lessons. Get the escrow money and take it straight to escrow. I mean, the earnest money. Get that handled right away. Do not delay on that. And if there's been a delay, get your Form 34 written up that you deposited that earnest money late, and make sure that it gets across to the listing agent and that everybody gets a signature on there, and get it turned into your office so that you've got that base covered. Provide a pamphlet on the law of real estate agency. Yeah. I have found that one of the easiest things to do is to have a template already ready in my transaction section of the matrix. In the multiple, there's something in there where there's a transaction desk, and it's got like all the forms. I can do authentisigns, and so I have basic templates, and I put my pamphlets in there for the 22J for the mold disclosure forms. I put the law of real estate agency in there. I put the wire fraud addendum in there. I put the FERPTA page in there, and I think those are the only ones that I have in there. Oh, there's a mold disclosure that I have in there too. And that goes across to all of my clients that I send stuff to. Every time I send some kind of template or something like that, it just autofills. And then I have them initial on one of those pages so that I can show that I sent that across, because I've been to court 4 times over the years. I would like to not lose. So far, I've been lucky, knock on plastic, but I'd like to keep it that way. Disclose whom they represent. Yeah, I represent the seller, I represent the buyer, I represent myself. Tell people who it is you're working for so they know who they're working with. Okay, the next slide we have is broker relationships. Reasonable skill and care. Reasonable skill and care indicate the obligation of the broker to perform their duties as an agent with the competence expected of someone in the real estate brokerage profession, and with reasonable caution, care. I'm not selling, I'm selling something worth hundreds of thousands of dollars for the most part. And so it's up to me to exemplify the appropriate amount of respect for the dollar that I'm working with. I'm not running a lemonade stand. The broker cannot claim to have exercised reasonable skill and care if they are doing something that a real estate broker would not do, given the typical skill and qualifications of the profession. I believe that means don't try and practice law if you're not a lawyer. Judgment is a large part of the real estate profession. Reasonable skill and care are not intended to mean that the broker cannot exercise judgment, only that they must not be negligent and irresponsible. For example, if a broker makes a judgment by giving an opinion of value on a property as 550,000 and the property sells for 575, this would not violate the duty of reasonable skill and care. The opinion of value is within the bounds of the broker's duty and could be made by a number of qualified real estate professionals. If, however, a broker urges a seller to enter into a contract offering $275,000 for a property that should be worth 550, this would be an example of failing to exercise reasonable skill and care. I am not the buyer. I am not the seller. That has helped me so much to know over the years. I am not the one who's making the end money. I am not the one who is selling my mother's house. I am not the one who is buying my future dream home. I am the person facilitating that transaction. I don't speak for my clients. I don't make decisions for my clients. I present my clients with what there is, and then I ask my clients to please give me their best decision, and I proceed forward from there, usually in writing. I do my best to educate them on whatever it is my job to tell them, and the rest comes together. Deal honestly and in good faith. Dealing honestly is easy enough. If you deal honestly while acting on behalf of a principal, you are halfway there in this duty. Dealing honestly does not imply that you must not give opinions, but you cannot misrepresent facts. The other part of this requires that an agent operates in good faith, which means being open, fair, and sincere. An agent cannot be duplicitous or deceitful. Having an ulterior motive, one that is not known to the principal, would be an example of violating this principle. This duty applies to all parties in a transaction, not just to the principal who the agent represents. I am more than my commission. I have passed up a lot of commissions over the years because it was in my client's best interest. There's lots of houses out there, and me urging a client to buy or sell a property just so I can make a buck will never work out well for me. So it's not something that I do. And many times I may come out of a listing transaction not well liked by my client until later on, because a lot of times it's my job to be the messenger and to state the hard facts that they may not want to hear. But my job is to help my client successfully navigate a real estate transaction and do the best I can for them to be able to make every choice that's in their best interest. Present communications. This requirement is to present all written offers, written notices, and other written communications to and from either party in a timely manner, regardless of whether the property is subject to an existing contract for sale or the buyer is already a party to an existing contract to purchase. The long and short of this duty is that you need to make sure that all written information is quickly given and presented to your client. There is no situation where you can hold an offer back so that another can be signed. The hardest part is the obligation to remember that you need to present all communications and offers from any party, even if you have a transaction that is under contract. As a broker, keeping the files and communications relating to a transaction is critical. This is an important practice to demonstrate that you have fulfilled your duty to present all communications in case you are ever questioned about a transaction. Noting the time and date that you received each communication is extremely helpful if there are questions. Email is especially useful because the timestamp is included. The same goes for me when it comes to text messages. They show the time and the date that they came through. Sorry about that. I have my dogs at the house right now. Broker relationships. Disclosure of facts. This is the requirement to disclose all existing material facts known by the broker and not apparent or readily ascertainable to a party. It is not to be construed to imply any duty to investigate matters that you have not agreed to investigate. I'm going to read that one again because it's super important. So it's called disclosure of facts. And if you are careless with this, it will burn you. And what they're talking about right now, I believe, is inspections. Disclosure of facts. This is the requirement to disclose all existing material facts known by the broker and not apparent or readily ascertainable to a party. It is not to be construed to imply any duty to investigate matters that you have not agreed to investigate. A material fact is anything that, if it were known, might result in a different decision. While this is rather broad, it is best to consider anything affecting the value of the real estate property as a material fact. What this means is that if you have knowledge of a fact pertaining to the property, it needs to be disclosed to every party involved. Even a broker who represents the seller must disclose material facts to a buyer, regardless of whether it is detrimental to the seller. If there was a leak in the bathroom that was covered with drywall and not visible, the broker would still be required to disclose that information to the buyer. That makes sense, to the buyer. This situation is an example of a latent defect. Latent defects are issues with the property that are not discoverable by the standard inspection. One type of disclosure that comes up is stigmatized property, or a property that has had a bad event occur there, such as a drug deal, crime, or suicide. Negative events are not by their nature physical defects and therefore do not constitute material facts. A stigmatized property does not need to be disclosed during the sale of the property. So this is something that has affected me multiple times in my career. If you ask me if a house is haunted and the seller has told me this house is haunted, I've seen ghosts in here. Number one, that's always a broker question for me. I always go to my broker and say, what should I say in response to this if this comes up? And it's a case by case basis. I didn't see a ghost in the house. I don't know if the person drinks. Is gossip something that needs to be disclosed? I don't think so. On the other hand, I have had to represent sellers where someone has been murdered in the property. And so if the buyer asks me, has someone been murdered in the property? I'm going to say yes on that one. I'm going to have to. And I will already have discussed that with my clients. It literally happened that I had a place listed that about a month into the listing, the neighbors came to me and said, how are you handling the fact that someone got murdered in the house? Are you disclosing that? And I had to go to my broker and my sellers and say, hey, is this true? It doesn't mean I had to disclose it in the listing and be like, hey, come and show my listing. Someone got killed here. But it does mean that if it came up, it is something that I would have to say, you should Google it. You should, if you have a question, you should Google it. And that's enough right there. Sorry, I have new puppies in the background, little babies. I could show you guys one real quick. Sounds like they're getting upset. This is my new English Bulldog puppy, Lewis. He's like a month old. He's just learning about life. He's been studying a little bit of real estate. He has a brother running around named Clark. Maybe he'll come over pretty soon. Okay. Account for all money and property. This duty is to account in a timely manner for all money and property received from or on behalf of either party. This particularly applies to the earnest money. Earnest money has strict rules regarding its handling. Rules are in place to ensure proper accounting. The accounting for all money and property also means that the broker must establish a chain of custody over a client's property or money. A chain of custody is an accounting that keeps a record of who has money or property at any given time. So if a broker receives money at 9 a.m. on a Monday and delivers the earnest money to the party set forth in the agreement at 1 p.m. on Monday, they will need to keep proper accounting of who had possession of the money, dates, and times. When a buyer presents an earnest money check or cash to a real estate broker, there are strict trust and legal requirements that control how the funds will be handled. I'm supposed to get your earnest money within 2 days of us signing the purchase and sale. And I think last week I got a purchase and sale signed around maybe on Thursday. And I didn't meet up with the client on Friday. So I didn't pick the earnest money up till Monday because I didn't want to hold it over the weekend when escrow was closed. I don't want that on me, right? So I picked it up on Monday, went and got my receipt. And like I said, I'm going to have to now do an addendum that says that I didn't deposit that earnest money until Monday because I had it for multiple days. Okay, so the next thing we're going to cover is broker relationships. Provide agency pamphlet. Brokers should provide a pamphlet explaining the law of real estate agency to all parties to whom they render real estate brokerage services. Before the party signs an agency agreement with the broker, signs an offer in a real estate transaction handled by the broker, consents to dual agency, or waives any rights, whichever occurs earliest. The MLS, that you belong to in Washington State, for me, will have many pre-printed forms that you can use to write transactions. And one of these is a pamphlet on the law of real estate agency. Like I told you, I have it in my basic template that I use. The pamphlet lays out the items that must be communicated to the broker's client as required by Washington state law. A good rule of thumb is to give the pamphlet to any clients the first time you meet with them. Be sure to do so, even if the client has worked with another broker and received the pamphlet from them. For me, on my website, I have a copy of some of the forms that you're going to need. One of them is the law of real estate agency. You can just download it right off my website and read through it yourself so that you know what's going to happen. And this isn't some like big, oh, what is this process like? That way it makes you more comfortable. Disclose representation. Buyers should disclose in writing to all parties for whom they provide real estate brokerage services before the party signs an offer in a real estate transaction handled by the broker, whether the broker represents the buyer, the seller, both parties, or neither party. I love saying I represent neither party because then if a lawsuit happens, I can say I didn't represent anybody, but usually it's not the case. If you're writing something up, you're representing somebody, and it's implied by the fact that you wrote it up. The disclosure must be in a separate paragraph entitled Agency Disclosure in the agreement between the buyer and seller, or in a separate document entitled Agency Disclosure. This requirement is intended to clearly establish who is representing whom. There are times when this is particularly important. For example, when a listing broker writes up a transaction for a buyer on the property and is not going to be a dual agent representing both parties, the buyer would need to know that they are not being represented in the transaction. You notice that all they said was the buyer would need to know that they're not being represented in the transaction. You represent the seller all day long in our state. So if you're doing some kind of business, chances are you're representing the seller. What's up, Lewis? Not a required duty. Unless otherwise agreed, a broker owes no duty to conduct an independent inspection of the property or an independent investigation of either party's financial condition, or to independently verify the accuracy or completeness of any statement made by either party or by any source reasonably believed by the broker to be reliable. This provides brokers with a limit to the amount of knowledge they should have about a property. Stay in your own lane. That's what that says. Stay in your own lane. And if you don't stay in your own lane, be prepared for lots of problems during all of your real estate transactions. Broker relationships, agency duties owed to clients. When a broker is acting on behalf of a buyer or seller, or as a dual agent, the broker owes additional duties to their clients, principals, in addition to those duties we just discussed that are owed to the parties. They owe loyalty, disclosure of any conflicts of interest, advice that they seek expert advice for issues outside the broker's area of expertise, confidentiality. Loyalty. To be loyal means taking no action that is adverse or detrimental to the client's interest in a transaction. That includes gossip. Conflicts of interest. This means disclosing any conflict of interest in a timely fashion. If the buyer turns out to be your brother's girlfriend, you need to disclose that because there may be some behind the scenes communication that either needs to not happen or the seller needs to hold back on telling you certain things so that it doesn't come out. Expert advice. This means advising the client to seek expert advice on matters relating to the transaction that are beyond the agent's expertise. I'm not a lawyer. I'm definitely not a tax professional. So don't expect me to know the answers to those types of things. Confidentiality. Confidentiality means not to disclose any confidential information from or about the client except under subpoena or court order, even after termination of the agency relationship. The confidentiality that a broker owes to the principal does not have an expiration. It is my job to never disclose what you have told me unless I have been ordered to do so. That's a high level of of a fiduciary relationship really is I got your back. I'd rather not hear stuff I don't have to, though. Um, Example, the listing broker knows that the lowest amount that the seller would be willing to accept is $729. During an open house, a potential buyer visits and asks the listing broker, "What's the lowest price that the seller will take for this home?" The broker replies that he represents the seller and that the visitor should make a solid offer. This is a great example of effective representation, confidentiality, and acting in the best interest of the client. Confidential information means information from or concerning a principal of a broker that was acquired by the broker during the course of agency relationship with the principal. The principal reasonably expects it to be kept confidential. The principal has not disclosed or authorized it to be disclosed to third parties. If disclosed, would operate to the detriment of the principal, and the principal personally would not be obligated to disclose to the other party. Broker relationships, exemptions, and allowable actions. The following are exceptions and allowable actions for a broker who is representing the seller agency. 1. A broker that is a seller's agent is not obligated to seek additional offers to purchase the property while it is subject to an existing contract for sale. 2. The showing of properties owned by the seller to prospective buyers or the listing of competing properties for sale by a seller's agent does not breach the duty of loyalty to the seller or create a conflict of interest. So if I go show other properties to a buyer, I'm not being disloyal to the seller. The representation of more than one seller by different brokers within a firm with transactions from the same buyer does not breach the duty of loyalty to the sellers or create a conflict of interest. The following are exceptions and allowable actions for a broker who is representing the buyer agency. 1. The representation of more than one buyer by different brokers with the same firm and involving the same property does not breach the duty of loyalty to the buyer or create a conflict of interest. If two buyers have two agents from the same brokerage and they both want to make offers on one seller's property, that's not a conflict of interest. A buyer's agent is not obligated to seek additional properties to purchase while the buyer is a party to an existing contract to purchase or show properties where there is no written agreement to pay compensation to the buyer's agent. I don't have to try and find you other houses while we're in contract. The showing of a property that a buyer interested in to other prospective buyers by a buyer's agent does not breach the duty of loyalty to the buyer or create a conflict of interest. If I show the same house to different buyers, that's okay. I can do that. All listed exceptions are allowable actions for both the buyer's and seller's agents. Also apply to a broker acting as a dual agent. The real estate agency pamphlet that is required must be given to all parties who receive real estate brokerage services and will contain the laws that explicitly codify everything we have just discussed under the requirements of the agency. It is important for you to be able to follow these laws, not only to have a thorough understanding of the laws, but also because you will most likely be answering questions from clients who will want to know the meaning of certain provisions of the pamphlet. The purpose of giving all clients the pamphlet and the clear disclosure of representation, who represents whom, is aimed at transparency and clarity. The laws are designed to make the real estate profession and its required duties less esoteric and more public. That makes sense. It's kind of like a do no harm thing. Broker relationships, types of agency brokerage relationships. Brokerages and their affiliated licensees, brokers, enter into agency relationships all the time. It is essentially the basis of the brokerage business. There are multiple types of agencies that the brokerage will choose depending on whom it represents in a particular transaction. It is interesting to note that the relationships formed under agency law are transaction based. This means that in most cases, a broker will enter into an agency agreement with a principal for a particular transaction, but there is nothing precluding the principal from beginning another agency relationship with another broker or brokerage firm for a separate transaction. I'm not your only realtor. Got it. For the purposes of this section, we will be discussing the types of agency from the point of view of the broker, unless otherwise noted. However, any managing broker or designated broker acting in a management capacity is bound to provide the same agency duties as the broker. Let me read that part again. It sounds a little convoluted. For the purposes of this section, we will be discussing the types of agencies from the point of view of the broker. That's me, unless otherwise noted. However, any managing broker or designated broker, that's my boss, acting in a management capacity is bound to provide the same agency duties as the broker, unless they are a dual agent. A managing broker or designated broker can be acting as a dual agency even when the individual broker is not, if another broker in the firm is an agent for a party on the other side of the transaction. That totally makes sense. So if I have my listing up at 1431 Oaks and say Wayne from the office is representing the buyer in the deal, then that means my boss, William, is a dual agent to these clients because he has two sub agents working on the same transaction. We learned that a while ago. So even if I, as the sub agent, am not a dual agent, my broker could be a dual agent. Seller agency. The relationship is between the broker and the seller, owner of the property, my guy on Oaks. The broker has a statutory, legal, remember that was written, responsibility to the seller of confidentiality, loyalty, and disclosure of any conflicts of interest, and a duty to advise their client to seek expert advice for situations outside the broker's area of expertise. So I wonder if that means that I need to disclose to my seller that my broker is a dual agent in the transaction when I'm presenting Wayne's offer from my office. I think for me personally, I like honesty. I'm going to let my client know that. I'm going to say this probably won't have any effect on our transaction since I don't have your buyer, but I just wanted to let you know that we are doing a deal with another broker from my office. Okay, so here's an example. John, a licensee with ABC Realty, has a listing with the Smiths and is the seller's broker. John also has his own home listed for sale at the same time. John's house is very similar to the Smiths. This already is making me a little nervous. While holding an open house for the Smiths, John meets a potential buyer. John suggests to the buyer that he should view his home and tells him that this is a better value in a nicer neighborhood. John puts his own best interest before that of the Smiths. Yeah, he did, because he wanted to sell his own house first. The Smiths sued John for a conflict of interest. Yeah, if I was the Smiths, I'd be pretty hot. The most common form of seller agency disclosure would be in a listing agreement. The following is from the exclusive sale and listing agreement. Seller authorizes the firm to appoint, blah, 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 that's where my name would be, as the seller's listing broker. This agency creates an agency relationship with listing broker and any of the firm's brokers who supervise listing broker's performance as seller's agent. Supervising broker, my boss, William. No other brokers affiliated with the firm are agents of the seller. Wayne is not, except to the extent that the firm, in its discretion, appoints other brokers to act on the seller's behalf as and when needed. If the property is sold to a buyer represented by one of the firm's brokers other than the listing broker, the buyer's broker, Seller consents to any supervising broker, William, who also supervises the buyer's broker, Wayne, acting as a dual agent. If the property is sold to a buyer who the listing agent, me, Stacy, also represents, seller consents to listing broker and supervising broker acting as dual agents. If any of the firm's brokers act as dual agents, the firm shall be entitled to the entire commission payable under this agreement, plus any additional compensation firm may have negotiated with the buyer. However, seller acknowledges receipt of the pamphlet entitled The Law of Real Estate Agency. This provision provides the necessary disclosure for the brokerage regarding their agency representation and a condition that the supervising broker can act as a dual agency if the property is sold by another broker affiliated with the firm. Note that the paragraph says that the seller has received the Law of Real Estate Agency pamphlet. It is essential that this pamphlet is provided prior to any principal signing a contract. There is another agreement that explicitly states the agency representation called agency disclosure. Okay, so we want to make sure everybody knows who we're working for. Buyer agency. This relationship is between the buyer or potential buyer and the broker, buyer broker, that's me. The real estate broker is employed by the buyer, that's if I'm showing houses to a buyer, to act as an agent and has a statutory written responsibility of confidentiality, loyalty, and disclosure of any conflicts of interest and a duty to advise their client to seek expert advice for situations outside the broker's area of expertise. The buyer's broker may be compensated by the buyer, the seller, or both. The source of the compensation does not change the duties of the buyer's agent to the buyer. The responsibilities required of the managing broker who is tasked with supervising the broker are the same as for the broker. So my boss has the same responsibilities as me. The managing broker is also bound by confidentiality, loyalty, and disclosure of any conflict of interest and a duty to advise them to seek expert advice when a topic is outside of the managing broker's expertise. Get a lawyer. These duties are required of not only the supervising managing broker, but of any designated broker and the firm. This is the truth with all types of agencies where any supervising managing broker has the same duties to the client as the broker does. The deviation from this basic concept occurs in dual agency. It is possible for a managing broker, designated broker, and firm to act as dual agent in a transaction while the broker is not acting as a dual. And we talked about that, like if Wayne and I are selling a house together. Broker relationships. An example would be a buyer agency agreement signed by both the broker and the prospective buyer. Let's look at an example of liability with a buyer agency. Example, Paige is a buyer's broker for the Gilberts. Paige takes the Gilberts on a tour of a home that appears to match all their criteria. The home is also priced well under market value. Paige discourages the Gilberts from considering the home by telling them that it is in a heavy crime area. Paige later informs her brother that he should buy this home for investment and that it is of great value. Paige was not loyal to her buyers and also did not disclose the conflict of interest. The most common form of a buyer agency agreement is the buyer agency contract. It is a sound practice for all brokers to secure this contract with all potential buyers. When a potential buyer agrees to sign this document, they're stating their intentions of loyalty to their broker. In turn, the broker is stating their loyalties to the buyer. If there is a dispute between brokers regarding procuring cause, who brought the buyer to the transaction, this agreement could be used as proof of representation. There is also a built-in disclosure in a standard purchase and sale agreement. Here is a look at the paragraph. That's a really solid thing that they just read. So when a potential buyer agrees to sign the document, they are stating their intentions of loyalty to their broker. In turn, the broker is stating their loyalty to the buyer. If there is a dispute between brokers regarding procuring cause, who brought the buyer to the transaction, this agreement could be used as proof of representation. What that means is many years ago, on a weekend, a buyer looked at one of my listings on a drive-by and asked me to write it up over the weekend. And on Monday, an agent contacted me and said I owed them a commission because that was their buyer. And in that situation, as the listing agent, you then have to decide who has the relationship with the buyer and who gets the commission. Will you refer that commission to that agent that said that that was their buyer that you met and wrote the contract up for? Or will you say, sorry, I guess you should have written that contract up? Quiet, puppies. Princess, that's enough. All right, agency disclosure. Selling firm. Selling firm's designated broker. Selling brokers. Just a minute. Hated to break up their playtime, but we're almost done with this section, and it's pretty important. Agency disclosure. Selling firm. Selling firm's designated broker, selling broker's branch manager, if any, and selling broker's managing broker, if any, represent the same party. The selling broker that selling party broker represents. So if I'm representing the buyer, William, my boss, also represents the buyer. Listing firm, listing firm's designated broker, listing broker's branch manager, if any, and listing broker's managing broker, if any, represent the same party that the listing broker represents. If selling broker and listing broker are different persons affiliated with the same firm, then both buyer and seller confirm their consent to the designated broker, branch manager, and managing broker, if any, representing both parties as dual agents. If selling broker and listing broker are the same people representing both parties, then both buyer and seller confirm their consent to that person and his or her designated broker, branch manager, and managing broker, representing both parties as dual agents. All parties acknowledge receipt of the pamphlet, The Law of Real Estate Agency. This provides for the dual agency by any supervising broker so that the broker is making it clear that they can act in that capacity if two affiliated brokers are working on the transaction together. It even allows for a broker to be a dual agent, although the compensation needs to be written and acknowledged in that case. So that can get real dicey. My listing on 1431 Oaks, I represent the seller. If I also represent the buyer, and the inspection is done and the buyer wants to negotiate for inspection items, and the seller wants to negotiate out of inspection items, that puts me in a precarious situation. Last time I did a dual agency, that's one of those times where I said that I represented neither party. But like I told you, if I made it in front of a judge, if there was a problem, the judge would have definitely said that I always represent the seller. And then they would have decided if I represent the buyer as well. I chose neither party, as I said, because it wasn't a listing. It was just a for sale by owner that I was doing the paperwork for. But the easiest thing I found was to have all of us sit down at the table and go over the inspection together, just at one time. Dual agency, and that's worst case scenario, dual agency and an inspection. Dual agency and anything to do with price. Dual agency and a low appraisal. Dual agency, if there is anything that has to be negotiated in the transaction, that's real hard for me to negotiate with myself against myself at the same time. And so that's important where I remember that thing that we talked about. I'm not the client. I don't speak for the client. I present the facts in a business, non-emotional way. And I sit back and I wait for the client to make their decision. Dual agency. A broker may act as a dual agent only with the written consent of both parties to the transaction. After the broker has provided a pamphlet on the law of real estate agency to all parties. So I'm getting a common theme out of this. present the law of real estate agency and get an initial on the front page, get a copy back. The written consent must include a statement of the terms of compensation. I have to have it in writing. How much am I going to get paid for this? Don't just leave that up in the air. A dual agency is when a seller represents okay, so this is one, and oh, that one's real squirmy. Look at this. This is the second one. They're brothers. This guy, super wild. You can hear him making all this noise. This guy, super sweet. Say hey, guys. Say hey. Hey, what's up? Hey, what's up? Okay, get out of here, you little maniacs. Oh, sorry. I need to drop it back like that. Whew. Okay, we're almost done with these slides. We only have 2 left. A dual agency is when a broker represents both the buyer and the seller in a transaction. This is legal in Washington state, although it is prohibited in other states. An often overlooked distinction is when the designated broker or appointed managing broker in charge of the supervision is a dual agent, even when a buyer and seller in a transaction are being represented by different brokers. We talked about this. Since the broker has promised a duty of confidentiality, loyalty, disclosure of any conflicts of interest, and advice to seek expert counsel for situations outside the broker's area of expertise to both parties simultaneously, it is necessary to limit these duties in this situation, if both parties agree. The dual agency relationship may have the following limitations. The broker must deal with the buyer and seller impartially. We talked about that where I had everybody meet at the table. The broker will have the duty to disclose conflicts of interest to both the buyers and the sellers. One of these things for me would be I own a landscaping company. And so I offer extra services like I'll help you move, not for free, but I do junk removal. I do repairs. And so I need to disclose these affiliated relationships that I have going on because it becomes more convoluted even at that point. The broker will not disclose confidential information about the buyer or the seller, including the broker will not disclose what the buyer is willing to pay or the terms that they will agree to or what the seller is willing to accept that they will agree to. The broker will not disclose the motivation of the buyer or seller unless authorized to do so in writing. Let's look at an example. Maria has a listing with the Grimes. A buyer visits an open house that Maria is holding for the Grimes property and asks if Maria will represent them with the purchase of the property. She decides to represent both parties of the transaction and thus becomes a dual agent. Let's look at an example of liability with consensual dual agency. Jane is a listing broker for the Andersons. Jane advertised the Andersons property, and from her advertisement, Jane finds a buyer for the home. She obtained written permission from both parties to act as a dual agent. After writing the contract and before presenting it to the Andersons, Jane learns that there is another offer that is very attractive. Jane hurries to Anderson's home and advises them to sign the first offer, wherein she was a dual agent, without presenting the other offer. Jane receives both sides of the commission because she represented both parties. And if she had represented the offer from another broker, she would have only received the listing portion of the commission. This was a violation of her duties to present all offers and a conflict of interest because she personally benefited from the signing of the transaction where she was a dual agent. The Andersons sued Jane for a violation of agency law. Ooh, ugly. Gotcha, Jane. Acting as a dual agent is fraught with complications and possible ways to violate Washington law because the broker has an obligation to both parties. Becoming a dual agent should be undertaken with extreme care. Trust me, I haven't done it very many times. It's a headache. Many brokerage firms do not want their licensees to engage in the dual agency because of the liability. Yeah, look at Jane, right? Wasn't worth that at all. She probably had to pay her lawyer too. She probably ended up losing both commissions by the time everything was said and done. She should have told her buyer to come up in price. I wonder if that would have been ethical. Who knows? Only Jane. Non-agency definition. When a broker is working with a buyer or seller, but not representing them, that's an actual question though. Not to digress, but it used to be back in the day that you could not share the details of an offer. And then it became more prevalent if someone made an offer that you could ask your broker, hey, another broker is asking me what my highest priced offer is. What should my response be? And if it's in your client's best interest, is it okay to divulge what your offers are priced at, how your offers are structured? Is it what is in your client's best interest to say, I would come in at least 10,000 over full price? Or do you say my highest and best is 10,000 over full price, conventional 30% down with no inspection? How much can you, as the broker's agent, disclose, and should you disclose? Incredibly important questions having to do with fiduciary responsibility. Okay. Non-agency definition. When a broker is working with a buyer or seller but not representing them, this is referred to as non-agency. The broker is working with a customer and not a client. They are acting in the capacity of a facilitator, remaining a neutral party to the transaction and supporting everyone through unbiased communication. Example, the Smiths approach Alan, who is a broker for ABC Realty. They have found a for sale by owner home that they want to purchase and would like Alan to write up the purchase and sale. Alan decides not to represent either party and states this in the contract. Alan is a facilitator and does not represent either the buyer, seller, or purchaser. Let's look at an example of a liability with a non-agency situation. Maria is writing up an offer for the Gilberts. She has expressed that she is not representing the Gilberts, both verbally and in writing. Even though she has done this, the Gilberts really did not understand and thought that Maria was their broker and representing them. The Gilberts tried to bring suit against Maria and her brokerage for not having representation. Designated agency. Within a brokerage, a situation may arise where one licensee who is affiliated with a brokerage is representing a seller, and another licensee affiliated with the same brokerage is representing the buyer in the same transaction. This situation is legal in Washington state, and the designated broker of the firm becomes a dual agent. In Washington, this is a dual agency, but it is sometimes referred to as a split agency or a designated agency. In a transaction in which different brokers affiliated with the same firm represent different parties, the firm's designated broker and any managing broker responsible for the supervision of both brokers is a dual agency and must obtain the written consent of both parties. In such a case, each of the brokers will solely represent the party with whom the broker has an agency relationship, unless all parties agree in writing that the broker is a dual agent. For each of the affiliated, let me read that sentence again. In such a case, each of the brokers will solely represent the party with whom the broker has an agency relationship, unless all parties agree in writing that the broker is a dual agent. For each of the affiliated licensees to work together, they must discuss only material facts so that they do not breach their duty of confidentiality. Example, John, an agent with XYZ Realty, has a listing. Peter, an agent with XYZ Realty, finds a buyer. The designated agency allows both John and Peter to represent their clients even though they work for the same brokerage. Let's look at some potential liability with the designated agency. Tom, a licensee with ABC Realty, has a listing. Pete, another licensee with ABC Realty, finds a buyer who would like to purchase this listing. Pete uses a conference room at the brokerage to write up the offer. While Pete is doing so, Tom listens in on the conversation that Pete has with his clients. Tom learns information that is considered confidential, such as the top price that the buyers are willing to pay. Tom relates this information to his sellers. A major conflict of interest exists here. The sellers rely on this action to the buyers, who bring suit against Tom for unethical behavior. All right, so that covers broker relationships, and that is Chapter 1 in Washington Brokerage Management. And for the next section, for Chapter 2, that's going to be brokerage supervision and liabilities. Stay tuned for more. Come back and listen to it.